Welcome back to Law Simplified. In our last masterclass, we established the ultimate formula of criminal liability. Actus reus plus mens rea equals to guilt. Today, we are taking that formula and applying it to the most serious charges in the Kenyan justice system, offenses against the person. We are opening the Penal Code, Cap 63 of the laws of Kenya, and breaking this down into two distinct categories: fatal offenses, where life is taken, and non-fatal offenses, where injury is inflicted. Let's get into the law. In Kenya, the taking of human life is categorized broadly as an unlawful homicide. The two primary charges you will face in your exams and in practice are murder and manslaughter. The actus reus for both is exactly the same: an unlawful act or omission that causes the death of a person. The difference between life in prison and the death penalty comes down entirely to the mens rea. So let's look at the first one, murder. Under section 203 of the Penal Code, it states that any person who of malice aforethought causes the death of another person by an unlawful act or omission is guilty of murder. The key word here is malice aforethought. What does the actual word mean? Under section 206, malice aforethought is established if the prosecution can prove any of the following elements. 1. An intention to cause the death of or to do grievous harm to any person. 2. Knowledge that the act or omission will probably cause the death of or grievous harm to some person. Then 3. An intent to commit a felony. Under section 204, the prescribed punishment for murder is death. You must absolutely mention the landmark case in the Supreme Court of Francis Karioko Muratetu and another versus Republic, a 2017 case. The court ruled that the mandatory nature of the death penalty for murder is unconstitutional. Judges now have the discretion to sentence a convict to a definitive term of years or life imprisonment based on the mitigating factors that were presented in the case. So let me give you a scenario. Imagine two individuals, Juma and Otieno, get into a heated argument at a local pub in Kiambu. Juma is humiliated. He leaves the pub, walks home, retrieves a panga, walks by and waits in the shadows for Otieno to leave. When Otieno steps out, Juma strikes him fatally. This is murder. Juma had the time to form the specific intent, and that is the malice aforethought, to cause grievous harm or death to Otieno. So to cement this, look at this famous case of the Republic versus Ruth Kamande, a 2015 case. The court deduced malice aforethought for the sheer number of stab wounds inflicted. In this case, there were 25 in total, proving a calculated, deliberated intention to kill rather than just injure. Then let's go to manslaughter. Under section 202, it defines any person who by an unlawful act or omission causes the death of another person is guilty of the felony termed as manslaughter. Notice what is missing: malice aforethought. The death occurred, but the specific intent to kill was absent. Under section 205, any person who commits the felony of manslaughter is liable to imprisonment for life. So let me give you an example. Let's go back to Juma and Otieno at the pub. This time, Juma does not go home for a weapon. Instead, during the heated sudden argument, Juma shoves Otieno forcefully. Otieno trips, hits his head hard on the concrete curb, and he dies from trauma. This is manslaughter. Juma committed the unlawful act, the shove, which caused the death, the actus reus, but he did not have the malice aforethought to kill Otieno, which would be the mens rea in this case. One key Kenyan authority here you need to know is the Republic versus Cholmondele, a 209 case, where the accused shot a stone mason in his estate. The charge was reduced to manslaughter because the state could not prove beyond reasonable doubt that he had malice aforethought required for murder. Then let's go to a crime called infanticide under section 210. If a woman causes the death of her child under the age of 12 months, but the balance of her mind is disturbed by the effects of giving birth or lactation, she is guilty of the felony of infanticide and is punished exactly as if she were guilty of manslaughter. The law recognizes the mental toll of childbirth as a mitigating factor in the said case. Before we move away from the life-threatening offenses, what happens when the accused tries to kill but fails? This brings us to attempted murder under section 220. The section states that any person who attempts unlawfully to cause the death of another person or the intent to cause death does not act like to endanger human life is guilty of a felony. Even though the victim survives, The law treats this with extreme severity. Attempted murder is punishable by imprisonment or life. So here is a trick examiners use to trap students. The mens rea for attempted murder is actually stricter than the actual murder. For actual murder, the intent to cause grievous harm is enough. But for attempted murder, you must prove the specific intent to kill. If you only intended to injure them, it is not attempted murder. Furthermore, the accused must have moved past mere preparation and committed an overt act. So let me give you a scenario. Juma decides he wants to kill Otieno. He goes to the agrovet and buys a deadly pesticide. This now is the preparation. He goes to the pub and pours the poison in Otieno's beer while Otieno is in the restroom, the overt act. However, Otieno returns, knocks the glass over by accident, and the beer spills. So, what charges does Juma face? Juma is guilty of attempted murder. He had the specific intent to kill, and pouring the poison was a direct, overt act that could have likely caused the death if not interrupted. Then let's go to non-fatal offenses, injuries. So, what happens when the victim survives an attack and the intent was not to kill? The Penal Code categorizes non-fatal offenses strictly by the severity of the harm caused. Let's go to the first offense, grievous harm, under Section 234. The most serious non-fatal offense is grievous harm. Under Section 234, any person who unlawfully does grievous harm to another is guilty of a felony and is liable to imprisonment for life. But what makes harm grievous? We look at Section 4 of the Penal Code. It defines grievous harm as any harm that amounts to a maim, dangerous harm, or which seriously or permanently injures the health, or which extends to permanent disfigurement or the permanent privation of the use of any external organ. So let me give you a scenario. So during a land dispute, a suspect uses a machete to sever the victim's hand. Because there is a permanent privation of the external organ, this is a clear-cut case of grievous harm under Section 234. So I would give you a case. The case law I would give you is in Nzioka versus the Republic. The court in this case emphasized that the injury must interfere seriously with the health or comfort to be classified as grievous. Okay, now let's go to assault occasioning actual bodily harm, ABH, under Section 251. So, Section 251 states, any person who unlawfully assaults another and thereby occasions him actual bodily harm is guilty of a misdemeanor and is liable to imprisonment for 5 years. So, actual bodily harm is any hurt or injury calculated to interfere with the health or comfort of the victim. It does not need to be permanent, but it must be more than just a trivial push. So let me give you a scenario. Mary and Sarah get into a physical altercation. Mary punches Sarah in the face, breaking her nose, and causes a deep cut that requires stitches. The nose will heal, so it is not a permanent grievous maim, but it is significantly interferes with Sarah's health. Mary will be charged under Section 251 for ABH, actual bodily harm. Now, let's go to common assault and battery under Section 250. Section 250 of the Penal Code states that any person who unlawfully assaults another is guilty of a misdemeanor and is liable to imprisonment for an year. In criminal law, you must understand that an assault does not necessarily require physical contact. Assault, what is assault? Assault is the intentional or reckless act that causes another person to apprehend or expect the immediate and unlawful application of force. Now that leads us to what is battery. Battery is the actual unlawful application of that force. So let me give you an example. Brian gets angry at Kevin. Brian balls up his fists and winds back and aggressively swings at Kevin's face. But Kevin ducks and the punch misses. Has the crime been committed? The answer here is yes. Even though Brian did not touch Kevin, he caused Kevin to expect immediate unlawful violence. That is common assault. If the punch had connected and left a simple bruise, it remains an assault punishable by up to 1 year under Section 250 of the Penal Code. So now let's go to the general defenses to wrap up this class. As a law student, your job isn't done when you identify the offense. You must look at the facts and ask, is there any legal justification that negates the Mens Rea. The first defense is provocation. Under Section 208, this is a partial defense, by the way. It does not lead to an acquittal. Instead, it reduces a charge of murder to manslaughter. It applies if the accused acted in the heat of passion caused by the sudden provocation before there was any time for the passion to cool down. So if there is already a cool down period, this defense sometimes is not sustained in a court of law. I will give you one case, Zakayo Itima versus Republic. The court established that even words alone in exceptional Kenyan contexts amounts to provocation. Then let's go to self-defense, the common defense everyone knows. Under Section 17 of the Penal Code, a person is not criminally liable for an act done in the exercise of their right to self-defense. However, the force used must be strictly proportionate to the threat. You cannot just shoot a man who is only threatening to slap you. It is not proportionate. Then let's go to the third one, insanity under Section 12. A mental disorder defense. A person is not criminally responsible for an act if, at the time of doing it, through any disease affecting his mind, he is incapable of understanding what he is doing or knowing what he ought not to do the act. Then we have intoxication under Section 13. Intoxication is generally not a defense unless the state of intoxication was caused without the person's consent by the malicious act of another, or if it produced a temporary state of insanity. And then, to remind you, we said insanity, the burden of proof for insanity lies on the accused. So it's for the accused to prove that they were insane at the time of the crime was committed. And the burden of proof does not lie on the prosecution side. And there you have it, the complete breakdown of offenses against persons under the Penal Code. You need to learn the definitions, master the punishments, and always spot the defenses. Make sure to subscribe, keep simplifying the law, and I will see you in the next one where we will be talking about offenses against property. Thank you for listening.